Imagine a situation when the performance of judicial proceedings is not implemented because of inactivity by the employee of compulsory enforcement service of judicial acts or lack of sufficient follow-up. How could be the plaintiff's actions? When officially appointed subject is not interested to meet its obligations for some reasons, then what kind of legal regulation can be expected? Truly, compulsory enforcement service has a duty of ensuring of compulsory implementation of judicial act, which means that it's not the debtor and the execution of the judicial act is not laid immediately on it, but obligation of forced implementation. The question arises in case of dereliction of working duties, the catchpole may be subjected to any liability. I talked about Part 2 of Article 353 of the Criminal Code, which is for officials of the organizations which foresees criminal liability. First part of the same article foresees criminal liability for state officials for non-performance of the judicial act. I think this applies to those cases when the debtor is the state by judicial act. It means a judicial act on the obligation implementation is laid on public body. It means that he agreed by decision, by court case. And if the court case is between two civil or legal entities and the state is not one of the parties of the case, whether it can be assumed that the compulsory enforcement service is doomed to anarchy. I'm also familiar with the practice when there has been launched a criminal case by Part 1 of the Article 353 against the body providing compulsory implementation, enforcement officer. I have no information about the result of the case, however, there is such practice too. But it doesn't refer to situations when the liability may be done only by the debtor, in which case the enforcement officer, in essence, doesn't have any means of compulsory implementation. There is no mechanism within the framework of compulsory execution for assuming that the enforcement officer or compulsory enforcement service performs the obligation instead of a debtor. In this case, the only way of compulsory execution is to compel the debtor.
քերական պատասխանատվության ենթադրյալ միջոցով, այսինքն արկադիր կատարման ծառայությունը ենթադրենք ինքը կարող է դիմել.
Forcing may be through the imposition of criminal liability. It means that compulsory enforcement services may apply to criminal prosecution bodies, presenting the facts and asking to give a legal assessment. Unfortunately, it must be noted that our legislation, civil legislation, doesn't have such way of protection of rights as a strand. I will make it clear what's that. There is such a regulation according to legislation of a number of countries, based on which, when the court imposes a particular responsibility on some person or the company, and this obligation is not fulfilled, the court may also lay a responsibility to pay a certain sum of money for each day of each delay for non-fulfillment of moral obligations. Now we have a similar setup for failure to fulfill financial obligations. If monetary liabilities are not fulfilled, then there are accrued interest by the central bank's interest for each day of delay. But we don't have such mechanisms for non-fulfillment of moral obligations. If there was such a mechanism and we invested that mechanism for each day of non-fulfillment of this obligation, in that case the company is required to pay to plaintiff some X money. First Armenian code familiar to the majority of our society was perhaps the judgment book of Mkhitar Ghosh. When we compare the codes acted in present days with the judgment book, we must say that the latter is much more sophisticated, and therefore we should expect the continuation of this process. So the question that at the present cannot be solved within the framework of the law can be resolved with the same law many years later. Հայր Փիաղաջանյան, Դավիթ Եսայան, Սյունիք Օնլայն։